Right. Looks like no one's joined us yet. Oh, here we go. There we go. So hi, everyone. Good morning. Thank you so much for joining us. Welcome to Navigating School Discipline in New York City. We will be getting started shortly. I'll just give, a few minutes for folks to trickle in. Once again, welcome, everyone. Thank you so much for joining. Today, we will be presenting on navigating school discipline in New York City. My name is Rohini Singh. I'm Assistant Director of the School Justice Project at Advocates for Children, and I will be one of your presenters today. I'm joined today by Ross Baker, who's our Special Education and School Discipline Advocate on the School Justice Project, and so he will also be joining us today for the presentation. So first, just so that everybody knows ahead of time, we will be sending out a copy of this PowerPoint after the presentation. And so please know that you will get a copy of all of the slides that we cover here today. In addition, during the presentation, I will pause a few times for questions. Just so folks know, the chat is disabled right now, but you can ask questions through the Q&A feature on your Zoom toolbar. So if you go to the Zoom toolbar, click Q&A, you can type any questions there. We're also joined today by another staff member from AFC, Liliana, who will be monitoring the Q&A and will either answer or read out questions that come up when we pause for questions. And finally, at the end of the presentation, we have a feedback survey that will pop up for you to fill out. We do ask that you fill that out. It's really important for us to be able to keep providing free webinars like this one to community members to gather that information. Great, so let us first kick it off with just a few introductory polls, just so that we get a sense of who's here in the room with us. And so, Liliana, if you could. So I'll wait a few minutes for folks to fill this in. Just so that we know, who's here, what type of information you're seeking, and where you're from. Thank you to those who are joining us now. We are just doing a quick attendee poll so that we know who's in the room with us, and then we will get started. Okay, I think there are just a few people who haven't filled it out. I'll just give it one more minute and then we can get started. We have a lot to cover today, so I don't want to wait too long. Okay, great. It looks like we have a representation from every borough, which is really wonderful to see, and some parents, educators, other professionals here. Thank you again for joining us. I am going to, here we go, share some of the results for the poll. And then, great, so let us keep moving here. Okay, oh, and then one more housekeeping note. This presentation will be recorded and it will be posted on our YouTube channel afterwards. And so if you have any questions about an individual situation, we will stop recording for a few minutes at the end of the presentation, and you could ask your question then at that time. But just so you know, this webinar is recorded and will be posted on our YouTube channel afterwards. Great, so let's kick it off. I'm going to be giving just a quick introduction about Advocates for Children and the School Justice Project and what we do. Then we will move into talking about types of suspensions and parents' rights in the suspension process. Then we will move to talk about legal protections for students with disabilities, which I know a few of you, in the poll when you signed up for this webinar had some questions on, so I hope we can answer those questions today. And then we'll talk a little bit about key takeaways when navigating the school discipline process in New York City. Just so folks know, the majority of this presentation applies to New York City public schools because we will be going over city regulations and city policies and practices when it comes to suspension. And so not all of the information that we are giving today applies to charter schools. However, when it does, we will mention that and I'll make sure to note that. So first, just a little bit about Advocates for Children. So what is AFC? So we're an independent agency that protects the rights of all New York City students. We have a number of different services. We have a citywide education helpline. The number is on the screen here and will be shared after the presentation as well. We have a number of guides and resources on our website, including a guide to school discipline, which covers a lot of the information that we'll be sharing here today, as well as a guide to MDRs, which covers the legal protections for students with disabilities in the discipline process. We also do a number of workshops and trainings, just like this one. And we provide the bulk of our services are free legal services to low-income families who are navigating the education and special education systems in New York City. And so Ross and I are part of the School Justice Project. And so our focus is on suspension and discipline work. And we help young people who are facing juvenile and/or criminal justice system involvement, school suspension, exclusion from school due to their behavior, or bullying behavior. And what we do on the School Justice Project is we advocate for alternatives to discipline and for behavior supports and services so that students remain in school. We believe strongly that punitive discipline and suspensions are often not the answer when a student is having behavioral challenges in school. We also participate in city and statewide coalitions to reform the school discipline policies and procedures, and we advocate for investments and supports for students, such as restorative practices, which we will talk a little bit about later in the presentation. So let's first talk about why this is important. So unfortunately, there have been a lot of studies that have shown that students who are suspended are more likely to miss class, be held back a grade, be suspended again, drop out, or get arrested. This is what's known as the school to prison pipeline. This is in part why we do our work, making sure that parents are aware of their rights in this process and why we help families and students navigate the school discipline system. Specifically in New York City, it's important to note that while overall suspensions have dropped across the city, there still is significant disproportionality in regards to who is being suspended. And so Black students make up approximately 22% of the population in New York City public schools, but they receive approximately 43% of all suspensions. And students with disabilities are 20% of the population, but they receive 40% of suspensions. This is why, again, we find it really important to ensure that parents are aware of their rights, students are aware of their rights in the process, and that we work with families to advocate for alternatives to discipline. So first, just to kick us off, we're going to do a quick intro poll. And so, Ross, if you don't mind launching that poll for folks. It's just to test a little bit of your knowledge about, parents and students' rights in school. And so the first question is, the school can call you to come pick your child up early. True or false? The second is, your child needs a doctor's approval to come back to school. True or false? The third is, after suspension, you have to meet with the principal before your child can come back to school. The fourth is, the principal can call EMS if they think your child is a danger to themselves and others. And the fifth is, a student can be suspended for a year. True or false? Great, thank you all for participating. We're getting responses, and it seems like it's pretty varied. I think just for the sake of time, you can probably end the poll and share the results now. Great. Are we sharing results now? I can't tell. Sorry. Yes. Okay. Okay, great. So thank you all for participating. I'll go over each one individually. So the first was, the school can call you to pick your child up early. So quite a lot of people put true. The answer is actually false. So We'll talk a bit later about the different types of discipline that exist and when a school can tell you to come pick your child up early or when they can send them home from school. But technically, a school should be able to manage a student in the school environment and in the classroom environment. And so if your child is experiencing behavioral challenges and the school is resorting to just calling you to pick them up early, that is actually not, they should not be able to do that. The second question was, your child needs a doctor's approval to come back to school. That is also false. Even if your child is transported to a hospital emergency room, there is some sort of medical concern that's related, they can't condition the student's return to school on any sort of doctor's note or doctor's approval. Your child is entitled to an education and is therefore entitled to go to school. After a suspension, you have to meet with a principal before your child can come back to school. That is also false. I know there are quite a few trues, some falses. Once a student has served a suspension, that suspension is over and their return to school can't be conditioned on the availability of a principal or the availability of the parent. There might be a meeting that is scheduled on their first day back from school, but that their return to school can't be postponed in order for that meeting to occur. The fourth one is the principal can call EMS if they think your child is a danger to themselves or others. So this is a trick question. I see there is also, again, a split. So yes, technically the standard for the principal to call EMS is if they think your child is a danger to themselves or others. However, every school, they must try to first safely de-escalate with strategies and interventions. And every school must have a crisis de-escalation plan that they are required to follow before they make a call to 911. So yes, technically they can call EMS, but again, they must be following their crisis de-escalation plan before they make that call to EMS. And then finally, a student can be suspended for a year. So some of you did get this correct. Yes, the student can be suspended for a year. Prior to 2019, it was unfortunately much more common for that to be a recommendation made at a long-term suspension. Since the changes to the discipline code in 2019, it is much more rare. However, it is still possible for very serious infractions to receive a year-long suspension. Great. So I will turn it over to Ross, who will talk a bit about types of suspensions and removals in New York City.
All right. So as Rohini mentioned before, my name is Ross, and I'm a school discipline and special education advocate on our school justice project here at Advocates for Children. So I'm going to talk a little bit about the types of suspensions and removals along with the discipline code and then kind of what happens following each type of suspension. So we have Bart here to help us, but to move on, we need, okay. So here are the two discipline codes. If you're a parent, hopefully you've seen these. All parents are required to have them, but sometimes schools won't provide them to parents right away. They'll offer them via links on their website or through email, or they'll provide them to students in school. But you'll notice that there are two different types. So there's a discipline code for students from grades kindergarten to 5th grade, and then a discipline code for students from 6th to 12th grade. So I guess I should back up a second and remind people that the discipline code is just a code and a set of guidelines for the school to adhere to as far as disciplinary possibilities, but then also requirements that the school must abide by in the disciplinary process. So today we're going to go over some of the infraction codes and then some of the possible disciplinary options to those codes. But it's also important to note that these discipline codes have parents' rights, students' rights, and they're supposed to be a measure of accountability for the school in enforcing discipline. So it's not just about, the discipline codes and the different infractions. But today, that's what we're going to focus on going forward. So this is an example of what some of the infractions look like. You'll notice that each infraction has a code, and there are different tiers of infractions. This is level 4, which sometimes can warrant what's called a superintendent suspension. But for each code, there is a corresponding range of disciplinary measures. So we can take a look at that one on the next slide here. So you'll see on the left side of the page that there are supports and interventions available. So as Rohini mentioned before, the goal of discipline is really to be progressive in that there's supposed to be small disciplinary measures set in addition to supports implemented after a behavioral issue. So you can see a lot of the supports that the district offers on the left side. And then on the right side is a range of possible disciplinary measures. And you'll see that the bottom has kind of like the most extreme or longest for a given infraction or code. It's great because there are a lot of different supports a school can offer. However, unfortunately, we often see that schools are just kind of like resorting to the bottom right hand side here where they're giving kind of the most serious end of the spectrum here. All right, so now I'm going to talk a little bit about the 3 types of suspensions. So the first that we'll talk about is a teacher's removal. A teacher's removal is the most informal of all the suspensions. And if you responded that the school can call you to pick up your student early, maybe what the school was trying to do was a teacher's removal, although there's specific guidelines around the teacher's removal along with all other suspensions. So it can only be up to 4 days. A parent can ask for a meeting, and a parent must be advised of via phone call. And for a teacher's removal, it's also important to remember that it's just a teacher's removal for a given class. It's not a removal from the entire school day. It's just from that class. And the student is supposed to go somewhere else in the school to get the instruction during that class period. The next one that I'll talk about is the principal suspension. So the principal suspension is up to 5 days. The principal must hold a conference, and a family must receive a written notice within 24 hours. So these are often kind of called in-school suspensions. Usually the alternative learning that takes place during a principal suspension is in the main office or another part of the school. But the school is required to give a family a written notice within 24 hours of the incident. And I'll talk a little bit more about each of these later. So the next is superintendent suspension. And this is kind of the most serious disciplinary measure there is. And this is from 6 to 20 days. It requires a formal hearing, which we'll discuss, and also requires 24-hour written notice. And it says 6 to 20 days here, but they can offer suspensions for more than 20 days. Fortunately, I think that's decreased a little bit, but we definitely still see that. So we'll talk about that more going forward. All right, so this is about other forms of discipline here. So although a student can be suspended for a year, students can only be expelled if they're over 17 and do not have an IEP. So what this means is any student under 17 cannot be expelled, and any student with an IEP is not able to be expelled either. Schools cannot use corporal punishment. I would hope that this is kind of like a given, but unfortunately we have seen cases where, schools are committing some type of bodily harm towards students, but this is explicitly prohibited in the discipline code and in the Students' Bill of Rights. And then the last thing, schools cannot transfer students without their permission. So unfortunately, again, we've seen instances where a school might say, the student's getting suspended a lot, or they're misbehaving a lot, we don't want to deal with them. We'd prefer if they go to another school. And although sometimes schools aren't the right fit for a certain student, the school doesn't have the authority to transfer a student without a permission. This is a decision ultimately made by the family and the student themselves. So this is a little bit more about principal suspension and the notice to parent. So a written notice is required by personal delivery within 24 hours. This term personal delivery is a little bit tricky because schools just have the responsibility to make sure that gets the parent within 24 hours. With that said, the school's idea of a personal delivery might be giving it to a student to give to their parent. And we've seen circumstances where that doesn't happen because for whatever reason, the student might lose it or the student might not want to give it to their parent. But it is the school's requirement to make sure that the parent has a written notice within 24 hours. In that notice, there's going to be a statement of students' rights, the reasons for the suspension, including the date, the time of the incident, and the date and time and place of the incident, the period of removal and alternative instruction. So like I mentioned before, for principal suspension, that's often in the main office or in a different part of the school where a student will report to receive instruction outside the classroom. And then the date, time, and place of the principal suspension conference. Okay, so we can continue. And I can talk a little bit more about that conference. So the student must stay in class until the suspension conference, except if threat or danger to the student body. So this is kind of, I saw one question in the chat that was sort of similar to this, but the threat of danger bit is a little bit tricky because ultimately the schools deem what a threat of danger is. So it can be tricky because there might be something that obviously is not a threat to the student's own safety or the school safety, but the school might maintain that, you know, they felt there was a safety threat and that might be the reason for the removal of the student from class. But students are typically supposed to stay in class until a suspension conference. The principal must attend the conference to decide if the suspension is justified. So the principal can't send someone there in their place. Even if it's a dean or assistant principal, the principal must attend. It's parents' right to make sure that the principal attends. Parents have a right to an interpreter, a right to present the student's version and question any witnesses involved in the incident. And then also a right to discuss a plan to address behavior. And this is something we want to highlight just because, you know, personally, I feel like suspensions aren't achieving a whole lot if there's not actually some discussion of how to address behavior and how the school can support the student going forward. And this kind of goes back to the piece of restorative practices that Rohini mentioned at the beginning of the presentation. So the next thing I'll talk about is a superintendent's suspension. So for a superintendent suspension, a school must get approval from the district and call the parent immediately. The parent must get written notice within 24 hours, including the reasons for suspension, alternative school location, details about the hearing, a witness list, and a parent's rights and places to call for help. So the alternative school location for superintendent suspension is typically at what's called an alternative learning center. And these are buildings that are different from the student's home school, where the student is supposed to report during their suspension to receive instruction. The details about the hearing are typically when and where the hearing will be, and the hearings are at a borough's suspension office. Each borough has one, except Brooklyn has two, and I think the Staten Island one is also combined with one of the Brooklyn hearing offices. Additionally, parents will get a witness list, so the people who are who can possibly show up at the hearing, and the people who wrote statements or report on the incident, and then the parents' rights and places to call for help. And that's often how we at Advocates for Children get a lot of our suspension cases, is our number is there. Parents will call us, we'll talk to them, and we can ultimately help with free representation at suspension hearings, as Rohini mentioned before. Okay, so this is a notice of superintendent suspension. So this is the formal notice that families are supposed to receive within 24 hours of a suspension. Here we have generic names. You'll see at the top, but it should have the family's address, the parent's name, and then the name of the student and the day of the suspension. You'll see that they have the Alternative Learning Center listed, as I said before. So this one would be in Brooklyn, and usually they're supposed to be in a student's borough and it's supposed to be as close to a student's house as possible. And if there are problems with the location of Alternative Learning Center, that's something that we often help families with to make sure that students are getting their education while suspended. And then at the bottom here, you'll see the date and time of the suspension hearing. And that's where the family would expect to appear to go to suspension hearing. And I'll talk through the suspension hearing in a few slides. All right, so this is the second part of a superintendent suspension notice. Again, or I think this is the first time I'm mentioning it here, but there's a suspension notice and a suspension packet. The suspension notice must be received within 24 hours. So this is still the notice, and this document tends to have less information in the packet. But you can see here that there's a brief description of the charge. So Sam student engaged in physically aggressive behavior as he swung his fist at Tina teacher. And then there's a sentence at the bottom, which is standard for every superintendent suspension. And at the bottom, as I mentioned before, you'll see the non-binding witness list. So these are witnesses who could show up at the hearing to discuss the case. And in this case, the witness is Tina teacher. Okay, so this is really important, the suspension packet, if your student receives a superintendent suspension. So this is a document that the school is required to provide families. And it's a little bit tricky because families are entitled to receive this before the suspension hearing. So sometimes schools might provide the packet the morning of the suspension hearing, which is really tricky because there's a lot of information, and the information in the packet kind of ultimately decides how families want to approach the suspension hearing. But in the packet, what you can expect to find is the occurrence report, or you might hear it referred to as an ORS report. And that's the official report that goes into kind of like the school or district's disciplinary database that describes the event, the time, the place, and sort of what happened. Witness statements, including from the student. So on the notice, you'll receive a list of witnesses, but in the packet, there's witness statements, which are written, which you can read, and they have people's account of what happened. A records cover sheet. So that's a sheet that will have just, this one's really important because it will have the recommended days that the school is giving the superintendent's office, along with current records for the student in school, an evidence voucher, any videos, any injury reports if there are injuries, and then other school records. So there should be disciplinary history, academic history, and IEPs included in these packets. And again, it is your parents' right, and it's really important that parents request these packets before the hearing as early as possible, just because these packets have really important information that can help how parents want to approach the hearings. Okay, so this is the first part of the records cover sheet. The cover sheet typically comes on like a legal piece of paper, so it's a little bit bigger than a regular one. So we're going to break it up into two parts. As you'll see, we have all the information here for the sake of the presentation redacted, but it will have students' current academic history or academic record, suspension history, and you can see here that there are small infractions like charges written, but that's representative of the suspension history, and then any transfers before. And the next part will have a synopsis of disciplinary record. So this isn't just for the one incident that this packet is about at the moment. This is just the history. There's also this portion that has prior guidance, interventions, and recommendations. And it's important that this is filled out, and also important that, the school actually has done a lot of the things that they say they've done here, because the goal of suspension or discipline is not for students to miss school. It's to help students and figure out what's going on. So if there have been no prior interventions, then it's really frustrating for students to get suspended because the school should be trying to work collaboratively with students and families to ensure that students are behaving and able to learn in school. And then you can see the dates of a current IEP if a student has an IEP. So it's important that this is recent, and Rohini is also going to talk a little bit more about protections for students with IEPs going forward. So I'll just put a pin in that for now. And then the bottom part is really important, but this is the principal's recommendation. So this isn't the end all be all of the suspension, but this is what the principal recommends for the amount of days. And this is something that's considered at the suspension hearing. This here is an example of a witness statement. So they look pretty informal, but they're written by the witness. So there's someone's name, their gender, their status, and then they write a statement. So sometimes in cases there will be several students writing statements. There will be school staff, and sometimes like the victim of an incident themselves. One thing to advise here to parents is that I'm going to talk a little bit about the suspension hearings going forward, but we advise families and students not to who might have committed a behavior infraction. We advise them not to write statements, just because if they admit to something in a statement, then it's a little bit harder to contest the charges at a hearing. So people are obviously within their right to write statements, but if a student is being disciplined for something, we would advise that they don't write a statement. Here's a copy of an occurrence report or an ORS report. So this is a document that goes into kind of the centralized system that will have the category of the charge, and then a little bit of a description of the occurrence, the date and the time. And then also you can see contacts here, which is important, whether the school contacted NYPD, EMS, or if they contacted someone else within the school district. Okay, so now we're going to get into the actual suspension hearing. So I've talked a little bit about the hearing, and I'll give a brief overview before I talk about the options that families have. So a hearing is held at the district suspension office. Usually the hearing officer is someone who is supposed to find facts in the case and then do kind of a disposition phase. So there's two phases. The first is the fact-finding phase, and this is where witnesses come and the school tries to prove the case of the suspension. It's important to know that the burden to prove the case is on the school. So families don't have to come and try to submit evidence that the student is innocent. It's on the school. And that kind of goes back to what I said in the witness statement, where it's for the better if students don't write a statement or admit to doing something, just because then the burden of proof is a little bit more difficult for the school. So the first option is an adjournment for good cause. This is when a family will request that a case be adjourned and that they meet later and the case is heard later than is initially on the suspension notice. Reasons for this might be a family was unfortunately provided documentation late and they want help, or they maybe and they only got the information late and they reach out to us, for example, and only get the packet late and want more time to look. So this is an option for families, but unfortunately any adjournment means that the suspension is going to likely last throughout the adjournment until the hearing. So it's just something to consider that it might prolong the suspension in some cases, but generally it doesn't, and it's so families have more time to prepare for the hearing. The next one is a plea of no contest. This one's a little bit complicated, but essentially, a plea of no contest means that a family and a student accept the charges, but they don't want to enter anything into evidence. So a plea of no contest, this also doesn't mean that whatever the principal's recommendation is going to be accepted by the suspension office. It just means that the family's saying, okay, we accept the charges, but we don't want any evidence in the record. And a reason why a family might do this is if the evidence is really is kind of worse than the charges. So an example here would be if a student got into a fight with another student and incidentally hit a teacher during the fight. And maybe they give a B36 as a charge and just describe that a student got in a fight with another student and a teacher was struck. But the evidence might show that a teacher might submit injury reports, and let's say the teacher was severely injured. Entering that evidence into the case would likely mean that the hearing officer might look at it and say, oh, okay, wow, this is significantly worse than we thought, and advocate for more time in the suspension. Another thing too is that if a family goes to a hearing and evidence is entered, that evidence can also be used if there's like a simultaneous criminal case about the incident. Whereas if a family pleads no contest, there's no evidence entered into the school record, just a charge. So I hope that makes sense. It's a little bit of a confusing charge, but that's typically why a family might do a plea of no contest. And then the third option is to proceed with the hearing. And as I mentioned before, there's two phases. The first is a fact-finding phase and the evidence phase, where the school must prove that what they're stating actually happened. And then the second phase is a dispositional phase, where the school and the family can kind of discuss the student's behavioral history. The student can get support from their community, from teachers, from other people in the school. And this is kind of so the suspension office has a more full picture of the student and isn't just hearing about this incident in a vacuum. And this is really an opportunity to advocate for the student and for the family. So post-hearing decision for superintendent suspension, within 2 days, parents must receive notification whether charges are dismissed or sustained. If the charge is sustained, where the student is assigned to attend school, so the alternative learning center. How suspension will be reflected in students' records, including when they'll be expunged. And then within 5 days, family must receive a full report of findings and dispositions to the parent. Families also can request a transcript of the hearing because the hearing officers take transcripts, and parents are within their right to request a hearing transcript. So if the charges are sustained, for most infractions, superintendents can immediately reinstate the student to school. So this might be if they don't agree with the recommendation of the principal, or the suspension time has already been served, or the superintendent can continue the suspension for 6 to 10, 11 to 15, or 16 to 20 school days. For very serious behavior, the DOE main office must approve a suspension of more than 20 days up to a year, and there's an automatic review for 40 or more days. And then the DOE main office also must approve expulsion. And again, as I mentioned before, there are those protections for students with IEPs and students who are under 17. And then also the superintendent is within their right to recommend services for the student and the family, and then grant or deny school transfer if the parent requests. So again, this is not the school involuntarily transferring a student out of the school, but there have been cases where we see a student get a superintendent suspension, and the family will say, you know what, we feel like the school and the administration just really have it out for our student, or don't like our student. We think we'd feel more comfortable if they were in a different school. And the superintendent can deny or grant a school transfer if the family requests after a superintendent's hearing. All right, so families have the right to appeal any type of suspension, really. This is more specifically about superintendent suspensions here, but the appeal must be in writing and state grounds for appeal. Families must file within 20 school days of the date of decision, or 10 school days from receipt of tape recording or hearing transcript, whichever is later. And then if that appeal is unsuccessful to the Chancellor or Office of Legal Services at the DOE, families then have the opportunity to appeal to the New York State Education Commissioner. Families must initiate this within 30 days of the decision unless the delay is excused by Commissioner for good cause shown in the petition. So this is good cause could be if the first appeal takes a really long time and they're not, the Chancellor's office does not do that in a timely manner.
Great. Thank you so much, Ross. I thought it would be a good time to maybe pause for some questions. It looks like there are that a lot of the questions have already been answered. Just a reminder, if you do have questions during this presentation, feel free to put them in the Q&A, and we have a staff member, Liliana, who will be answering them. And we can answer some live as well as we pause for questions.
I think this might be a good question for you. Regarding pleading no contest, can school override and insist on entering evidence into the record? Oh, sorry, I saw Liliana was typing to answer, but I feel like that's a good one.
Yeah, so no. So a school can't override a no contest plea. It is within a parent and student's rights to plead no contest. Again, you're not admitting or denying the charges, and you waive the right to the hearing, but the charges sort of remain. And then just based on what's written in the charges, the hearing office will determine how long a suspension. So no, a school cannot push for a hearing. The hearing is there to protect the parents and the student. And so you can waive that right to the hearing by pleading no contest, and the school cannot override that. Great. So we are going to move on and talk a little bit about alternative instruction and then about protections for students with disabilities. So we really want to emphasize that alternative instruction is required whenever a student is serving a suspension. So suspensions are not supposed to penalize students academically. And, we can't say that enough. And so students are entitled to homework, classwork, exams, and at times full-time instruction, either at the student school, a different school, or an alternative learning center. So for example, we're working with a few families whose students are on suspension, have been on suspension the past few weeks, and they have been able to return to their home school to take the state exams that are happening right now in middle school. So alternative instruction, again, during principal suspensions or while waiting for a suspension hearing in grades K through 8, you're entitled to full-time instruction. In high school, you're entitled to at least 2 hours a day. And after the suspension hearing, all students who continue to be suspended have a right to full-time instruction, again, as Ross mentioned, at that alternate learning center. So now we are going to turn to talk about protections for students with disabilities. So as we mentioned at the beginning of the presentation, suspensions are disproportionately imposed on students with disabilities. And this is true even though the law gives extra protections for students with disabilities who are being disciplined in schools. And so, as I mentioned earlier, these rights are included in federal education law. And so it's important to note that it applies to all students in public schools across New York State, as well as charter schools. And the 4 main protections are expedited evaluations, manifestation determination review meetings, the right to a suspension plan while a student is on suspension, and then the right to an FBA and BIP. Today, I'm going to discuss the first 3 of these in some detail. I won't be discussing in detail FBAs and BIPs, but we do have a separate webinar on behavior supports for students in school that I would recommend that you watch. It is on our YouTube channel, which covers FBAs and BIPs in greater detail. So who is the student with a disability for discipline purposes? So the first two categories are hopefully obvious. Students with IEPs and students with 504 plans are automatically entitled to the protections that we will be going over today. They are considered to be students with disabilities. However, there's a third category where a school is deemed to know that a child has a disability, where students might also be entitled to some of these special protections. And so what does it mean that the school is deemed to know that a child has a disability? It can be either that the parent expressed concern in writing to a teacher or administrator that their child may need special education. It could be that the parent had requested an evaluation for special education, but it had not yet been completed at the time of the suspension. It could be that teachers or school staff express specific concerns about a pattern of the student's behavior to their supervisors. This one's a little harder for parents or advocates to prove. And then in New York City, there is a fourth category when the child's behavior in school showed the need for special education services. And so even though a student does not yet have an IEP or a 504 plan, if they fall into one of these four categories, they could be considered that the school is deemed to know that the child has a disability. Some of the exceptions to this, if the parent did not consent to evaluations or services, so if the school had tried to initiate special education evaluations and tried to provide services, but the parent declined, then they would not then be able to claim this protection. And then if an evaluation was conducted and that the school district determined the child does not have a disability, that would again mean that the student would not necessarily be entitled to these special protections. So let's first cover the right to expedited evaluations. So suspended students must get expedited evaluations when a parent requests an initial special education evaluation at the time of suspension, or if the school is deemed to know the student has a disability. And these evaluations are expedited because they must be done within 15 days of parental consent. And then once the evaluation is completed, the school must hold an IEP meeting no later than 5 school days after completing the expedited evaluations. It's really important, to take advantage of this right to expedited evaluations if your child is going through the discipline process, because it really shortens the timeline to get evaluated and to get an IEP and services from 60 school days to 20 school days. And so that is a quite significant difference. And so it's if you need services quickly, this is a good mechanism to use to get expedited evaluations and an IEP for your child. Great. So now let's talk about one of the biggest protections for students with disabilities, and that is the manifestation determination review. So what is an MDR? So an MDR is a meeting that typically happens after a student is suspended or before a school is considering a suspension. And it's a meeting to determine whether or not the student's behavior was caused by the student's disability, or if it was a result of the school's failure to follow the student's IEP or BIP. And it's essentially a meeting where the parent, the student, anyone invited by the parent, and relevant school staff will sit and discuss the child's IEP, the child's disability, their evaluations, and determine what is their disability-related behavior and how does it relate to the specific incident. They'll also review the student's IEP or BIP and make sure that they're receiving all the services. And the purpose of the MDR is because if the student's behavior, if the answer to this question is yes, it was a manifestation. So if the student's behavior was caused by or related to their disability, then the student is not allowed to be suspended. They must return to their regular class placement, and the school must conduct an FBA to see if their child needs a BIP. If the student's behavior is not a manifestation, then the student can be suspended like other students. And if during the MDR, school's officials identify deficiencies in the student's IEP placement or implementation of the IEP, they must take immediate steps to remedy those deficiencies. In addition, if it's not found to be a manifestation and the student continues on suspension, then students with disabilities are entitled to what's called a suspension plan, which is a streamlined version of the IEP. So it'll include the services that the student will get while they're at their suspension site. So it won't necessarily be everything that they would get in their regular school on their IEP, but it's a little bit like a comparable service plan. It can include related services, sets, accommodations, transportation. And that suspension plan is usually prepared by the site where the student will serve the suspension. And again, it must allow a student to make progress towards their IEP goals, because as I mentioned earlier, suspensions are not supposed to penalize students academically. If a parent disagrees with the MDR decision, they can request an impartial hearing to appeal that. And the hearing must be done on an expedited basis. So it's scheduled within 15 days of filing. And something that I just want to note about MDRs, because oftentimes we do go to MDRs with families and there seems to be a misconception about what an MDR is, what its purpose is. So it's not about saying that the behavior was okay or sanctioning that, or not holding a student accountable. It really is just about the fact that if a student is truly a manifestation of a child's disability, then some form of punitive discipline is not the appropriate response. And so, this is something that we struggle with a bit. And I'm sure for those of you that have attended MDRs might have experienced some of this frustration, where at times the school, will not use the correct standard or not use the correct categories when asking if a behavior was a manifestation, because there is this misconception that it's about, that we're saying for some reason that students with disabilities should not be held accountable or can get away with X behavior. And that's really just not the case. This is about how do we support students? How do we effectively respond to behavioral challenges in a way to actually make behavior change? So when must the school hold an MDR? So the school is required to hold an MDR when the student is suspended for 11 or more days, either in a row, 11 or more days within a 40 school day period, or 11 or more days where there is some sort of pattern of behavior. It's really important because of this that parents and students keep track of, how long they've been removed or suspended. In New York City public schools, typically, when a principal or a dean puts suspensions or discipline into their database, once it hits this threshold, there should be something that prompts them to hold an MDR. However, there are cases where potentially maybe removals aren't being logged correctly or tracked correctly. And so keeping track of how many times your child has been suspended or removed will be important to know that the school is, or to push the school to do this MDR so that your child can get the support that they need. So as I mentioned, during the MDR, the team reviews the IEP, FBA, BIP, evaluations and teachers' observations, occurrence report, records from the parent, and any other information. You can provide letters of support or information to schools, from outside therapists, outside providers that can help support, the determination that a student's behavior is a manifestation of their disability. And then at the meeting, the team will go through what's called the MDR worksheet. We recommend, and we'll have a link to this on this slide, we recommend that you, if you're going to an MDR, either as a parent or as an advocate working with a student, that you print out this worksheet and make sure that the school is following the different prompts on the worksheet as they go through the meeting. So just some tips for preparing for the MDR. Again, as I mentioned before, reviewing all the documents. What I typically do before I attend an MDR for a family is I review all the students and all the students' records, and I go through the MDR worksheet and I actually pull out the instances of similar behavior or related behavior, to really try to demonstrate that the incident in question is a manifestation of the student's disability, that there has been a clear record and documentation of the student's behavioral challenges. And so because of that, the school must be responding with supports and services and not with punitive discipline. Making sure that the student is getting all their services on the IEP. So this is that second category for MDRs. So for example, if an incident occurred and a student has a paraprofessional on their IEP, but the paraprofessional wasn't there during the incident for whatever reason, then again, they should not be suspended because they were not getting all their services on their IEP at the time of the incident. It's the same as if there's a BIP and if the school wasn't following it. If that contributed to the behavior or the incident, then it should be found to be a manifestation. The student cannot be suspended. And again, as I mentioned, asking outside providers to participate can be really crucial here. So just some tips for using outside providers. They could participate in the meeting directly or write a letter of support that you can submit. And we recommend that the professional explains, how they know the student, for how long, explain what type of service they provide, write out the list of documents that they might have reviewed before reviewing the letter, before writing the letter, excuse me, if any, that they describe other similar incidents that they know about. And then at the end, to sort of state conclusively that they believe that this was a manifestation and explain why. So I have another pause for questions. It looks like we do not have any open questions right now. Okay, so I will move to talk a bit about our 5 school discipline takeaways. So the first is that schools should try to help students before suspending them. So as Ross mentioned, when he went over the discipline code, the second half of the discipline code lists all of the infractions and the different disciplinary responses, but the first half actually contains a lot of information about the different supports and interventions that schools should be able to provide students. And in some cases, it should be able to provide students prior to issuing a suspension. And so, we often try to use the discipline code as an advocacy tool when we're working with families and schools that are, sort of routinely resorting to discipline or suspension, to say, hey, have you tried some of these other options? And what can we do to reduce, the number of suspensions for a particular student? Second, in many cases, or at least for principal suspensions, superintendent suspensions, notices must be in writing. And this, this is more than just like an email or a text message. The notice must be sent and contain very specific information. And so if your child, you just get a call from a school saying they're being suspended, don't send them to school tomorrow. That is not an official notice, and that's not an official suspension. And so, our recommendation is to wait until you receive the notice before you keep your child home from school. In the case of principal suspensions, we recommend again that you ask for that principal suspension conference. As Ross went over, technically that should happen before the suspension actually takes place, except in very limited circumstances. And so, and again, it's an opportunity to talk about what happened and how to prevent it in the future. Even if you're not able to get the suspension removed or changed, it's at least an opportunity to talk about how to prevent future suspensions. We can't emphasize this next one enough. For superintendent suspensions, always get the packet. It's really crucial that you have this information so you know what the evidence is. And then also if you're seeking legal representation or advocates, they are also going to want to see the packet. And so the first question you should ask if a student has been suspended is, can I have a copy of the suspension packet? And then, as I mentioned a few times, students are entitled to alternative instruction. And so there's no such thing as an out of school suspension. Students being suspended, then they shouldn't be sitting at home. They should be receiving alternate instruction, either at an alternate learning center, their home school, or a different site, depending on their specific circumstances. And that is our presentation today. Please, if you can, fill out our survey. There will be, I believe it'll be launched shortly. I don't know if Liliana or Ross, you're able to do that now. If you need help, of course, please ask. You can call our helpline if you have a question related to any discipline or special education related issue. The number is 866-427-6033. We're open Monday through Thursday, 10 a.m. to 4 p.m. And you could also email us at info@advocatesforchildren.org. So thank you, everyone.